Good evening, everybody. We just waiting a few minutes for everybody to get connected and we'll get started. We'll just give everybody about another minute to log on, make sure that their cameras are working okay and that they can see us. We can't see you all, but we do know who's here. So thank you very much for joining us. Okay, it looks like there's a few more people joining. In the meantime, while we're having everybody join, thank you so much for joining us tonight. My name is Nicola Gray. I'm one of the senior associates here at Smith Kleinsmith, and we're joined tonight by Jacob Runyon, a senior associate with our firm, Ms. Charlie Kirby, whom I'm sure all of you have spoken to. Ms. Kirby is our firm's administrator and one of the most important people that you'll speak to as your case goes on. We also have Ms. Janine Mitchell, who is with us tonight, and she's also a senior associate with the firm, and we are thrilled to have you on. It looks like everybody who will be joining has joined, so we'll go ahead and get started. This is our town hall, just to give you a bit of information about the process and bring in a lawsuit. I know that not many of you have brought lawsuits before, and the process can be a little daunting. And so hopefully by going through this process, we'll help you at least know what to expect in the coming months and the coming years. So we understand that in deciding to hire a lawyer, there was a lot of thought that went into it. You came to us from an area of broken trust. You'd put your loved one in a facility and there was loss and uncertainty. What you expected the facility to do, they clearly had not done, which is generally why most people get in contact with us. And we know that this was a very big decision that both you and family members made in order to hire an attorney. Our main aim, as we are sure is your aim as well, is to get justice for your loved one or for yourself if you are the injured person, as well as to hold the facility accountable. As we go through your case, there's several stages that your case will go through. There's the intake and investigation, information gathering part of the case. There's the medical and pre-litigation section. We go through the litigation section. That one's mainly covered by the filing of a lawsuit, discovery, mediation. And then at the very tail end of your case, we have probate and administration. In terms of, our team, we've got little cartoon characters of your team. I think most of you have spoken to Bianca in the intake and investigation section of your case, and that's when you signed up the case. Medical and pre-litigation, that's me. Litigation, we've got several senior associates with litigation. You're joined by Jacob, who we've got a little caricature of there, and we have Ms. Janine Mitchell on with us tonight, and Charlie for probate and administration. In the pre-lit part of your case, by this time, you'll have spoken to myself or somebody in my department. It starts off when you've signed up your case with Bianca. The pre-litigation department gets your case. Pre-litigation is the investigation part of your case as well as the building of your case. It will start with doing an intake memo and a video call with one of our case managers. And during that call, you'll find, if you have not already done so already, we do ask a little bit about family information. And you'll find that during the entire life cycle of your case, the departments are very collaborative. So in the pre-lit process, we'll ask you about family info, because unfortunately, if our loved ones are deceased, we need to make sure that we have proper authority for bringing the case. We want to make sure that we've got all the heirs on the case, and while your case is in pre-lit, you may also hear from our probate coordinator, whose name is Laurie. So there is a lot of communication between the pre-lit department as well as the probate department in order to make sure that your case is ready for the next steps. We also do some research into the corporations that own the facility. We want to make sure that if the case does go forward to litigation, we have the correct defendants on the case. During the pre-lit process, and I would say that the biggest part of the pre-lit process is the process of requesting and receiving medical records and the billing information. During this time, case managers and our medical records clerks will be reaching out to you to possibly get additional authorizations signed by you, to get affidavits of heir signed, which the providers may need in order to release medical records. When we receive those medical records, we put it all into a nursing report. And in that nursing report, it kind of gives a chronology of your loved one's day-to-day in the facility. It also shows what breaches we have in the nursing standard of care by the facility. There are some states that require an expert to review the case before we can file it. And so we liaise with our experts who are experts in their field and experts in nursing home and assisted living nursing standards of care. And we have them review the case and almost get their rubber stamp of approval on the case. There are some states that do require us to file what is called an affidavit of merit or a certificate of merit, which is essentially the expert saying, yes, there is merit to file in the case. The facilities did do A, B, C wrong, and it resulted in a certain injury. So we do that all in the pre-lit stage, as well as doing lien investigation. And Charlie's going to speak to this a little bit more when we get to her part of the presentation this evening. But in doing so, as we go through your case, if your loved one is covered by Medicare or Medicaid, we do set up a lien as we are required to do in order for the government to be paid back. But as I said, Charlie will get into a lot more of that info. But that is essentially the pre-lit process of your case. And once your case has gone through the pre-lit process, it then will go on to the next steps of the case.
Good evening, everyone. After the case moves from the life cycle from pre-litigation and the medical records phase, we're going to be now moving into the litigation phase of the case. And that is when a lawsuit is ready to be filed. And that is where a majority of your case time here is going to be spent. So litigation is pretty lengthy, but I'll walk you guys through the process. So a lawsuit will be filed in the case and it'll move on to your litigation attorney. And then that person, as well as their paralegal, will be your point of contact going forward. A lawsuit, depending on the jurisdiction or the state where your case is filed, is going to be called either a complaint or a petition. Once the lawsuit has been filed, the complaint or the petition has been filed, then the defendants will be served a copy of that lawsuit. So it'll generally be their registered agent who is served with a copy of that lawsuit, and they will have 30 days to file what's called a responsive pleading. That responsive pleading can take many forms. It'll generally be an answer. So that means they're answering the lawsuit and entering what's called a general denial in the case. So denying the allegations, which is pretty standard. Or they will file a petition to compel arbitration, depending on whether or not an arbitration agreement's been signed, or some type of dispositive motion, such as a demur motion to strike. And I know those are some pretty big words, but it is those are different types of responsive pleadings that can be filed and kind of dictate how we're going to be moving forward with the case. After their responsive pleading's been filed, and so whether it's a challenge to the pleadings or just an answer in general denial, we will move to the discovery phase of the lawsuit. And you will all be receiving a notification once the case is filed, as well as a discovery questionnaire. And it is super important for us to have those discovery questionnaires completed and all necessary documents provided to us, because we're going to use those questionnaires as we move forward with discovery in the case. And discovery is going to be where the majority of the litigation phase of the lawsuit, it's going to take a majority of that time. So discovery is where we are seeking certain documents and seeking certain information from defendants, which will be our evidence in the case. So policies and procedures, the full medical chart, billing records, witness statements, and in turn, they will also be serving discovery on us. So seeking certain documents and seeking certain answers to questions. Additionally, in addition to written discovery, we will also be taking and defending depositions. So your deposition will likely be taken. We will also take the depositions of the directors of nursing, the administrators, and corporate representatives. So the most important people who are going to have a wealth of knowledge about what has gone on in your loved one's case. So that way we can gather more evidence and get testimony that'll help us out in the case. There also may be some motion practice during that time, such as motions to compel if we are requesting that the court compel them to provide certain information that they haven't provided, or to provide their people for deposition if they're refusing to do so. We also move forward with expert designations. We are required to have expert testimony in order to prove our cases. There's certain, the causes of actions we assert have certain elements which must be met, and we have our experts, which are generally a nurse expert, a physician expert, as well as an administrator expert who we designate, who will be providing that testimony. After that, we will move forward to either mediation or settlement. That can look a couple of different ways. So a case can informally resolve through sending out a demand in the case and negotiating with defense counsel, or through mediation, which is where a third party neutral who has no interest in the case, who is simply trying to facilitate a resolution, will go back and forth between the parties and try to come to some sort of settlement. However, if we are unable to settle the case, then we will move forward with preparing for trial, which our expert designation, our expert depositions will take place. We'll move forward with trial documentation, and then a court trial or a jury trial in the case. Or if a defendant's petition to compel arbitration has been granted, we will move forward with an arbitration proceeding. So there's some different ways in which a case can resolve. So mediation, settlement, or through the trial or arbitration process.
Awesome. Well, thanks, Janine. Appreciate that. So again, my name is Jacob Renyon. I work heavily with all the individuals on here throughout these various stages of the case. Just also want to mention real quick before we start talking about probate that the litigation phase is really kind of the longest phase of the litigation. You know, it can take really anywhere from 12 to 18 months just as soon as we actually get that case filed. So just to kind of give you an idea, we typically get that question asked a lot. It's really going to depend on the case and the facts and the circumstances, but plan on kind of that time frame. It can last that long, sometimes even longer. The next phase is kind of the probate phase. Now, the probate phase is not necessarily always going to come after the litigation phase. Sometimes it's going to begin in pre-lit with Nicola in her department. It's going to carry over into litigation. Depending on what state you are in, and the attorney working on the case, we handle many of the probates in-house with the firm. So the litigation attorney that's going to be assigned to your case could be doing the probate, and then we do lots of the probate with outside counsel where we don't have the ability to be able to do that in-house. And you're going to be working with Lori King. She's kind of our probate coordinator and kind of walking you through the probate process. Now, not all cases are going to require probate to be done. Probate's only going to be necessary where the injured party is deceased. And that is going to first consist of, we're going to do a family investigation, family memo, where we're going to ask for all the relatives and heirs of the estate. So whenever you're talking to Lori or other staff members, please recognize that we're not trying to be nosy. We're not trying to dig into your lives. Just because we need that. It's necessary to be able to file the probate action. And the probate action is a separate case from the litigation case that Janine just talked about. In that investigation, we'll figure out whether there was a will and testamentary, if there were any type of family agreements, trusts that possibly could have been actually filed. And then as soon as we know that information, we'll then know what type of probate action to commence in the courts. And again, depending on what state you live in, sometimes probate has to be done before we can even file the lawsuit. Sometimes we can file it during the pendency of the lawsuit, and then some states we can file it after. But essentially, the best way I've always known to describe what probate is it basically gives you a document, kind of like a power of attorney, when somebody's dead. So it's basically a power of attorney over a dead person's estate to be able to allow you and give that person authority to bring the cause of action. Without having probate done, that you or whatever family member is bringing the case will not have authority to be able to bring that case in the court. So it's necessary that we do get probate done on the case. And again, probate's only necessary if the injured party is actually deceased. But we'll get that probate petition filed with the court, and then basically we'll get a court approval. And then at the end of that process, we'll get letters of administration or letters testamentary, and that allows you or whatever family member is bringing the case to actually have authority to prosecute those claims against the defendant facility. So appreciate listening to us, and I'll turn the time over to Charlie for administration.
My name is Charlie. I work with the administration department. So we will start your case in intake. Sometimes my team will speak to you there. Otherwise, it may be Bianca or Erica. And then we close your case. We handle all the subrogation liens, the case cost, and the distribution of the settlement and the settlement agreement. So once your case is settled, you'll be hearing from us frequently. The client authority will start at the beginning. You may hear from Sandra or Samantha on my team asking to fill out certain documentation, to request Medicare and Medicaid subrogation liens. A subrogation is a legal claim that one party, typically an insurance company, has on a settlement or judgment proceeds received by another party. This lien allows the insurer to recover the amount paid for damages and injuries and losses caused by a third party. Most of that will come from Medicare and Medicaid. You'll get correspondence in the mail. If you do, we ask that you save it. We will answer all of those questions for you. You don't have to fill anything out or respond. We do take care of that for you, but we ask that you save that correspondence in the chance that we may not receive something, because it does take us a long time to get a copy of it back. And it's good for you to have for reference too during your case. So we just ask that you just put it in a small little manila folder or in a drawer that you can keep up with it until the end of your case. There are case costs affiliated with your case that we keep up with during this process. We front those costs for you. It may be a petition filing fee, service fees for a citation, medical record cost, expert cost, and of course, trial cost if it does go that way. We keep up with those for you, and that's recouped out of your settlement at the end. You do get an itemized of that, and we go over those with you in depth upon your distribution. If you have any questions, we can answer anything about those and what they did and what they were for. The settlement agreement that you'll receive from us after your case is settled, most of the time it requires a notarization. We will assist you with that and give you instructions on how to either sign it or get it notarized or any other documentation that needs to go with that. And then your distribution of your settlement. And you get an itemized breakdown of everything that happened in your case, the total settlement amount, the attorney fees, case cost, any liens that we have to pay back, that will all be broke down in that distribution. Your liens, we will work on most of the time during your case. Damages of those liens, they use in litigation to show damages, to show how much was paid out for those injuries, you know, what your family member went through and how much that cost them or Medicare for that treatment. So when you get those in the mail, you're welcome to call us if you have any questions on it, but we do 90% of the time get the same copy as you do. During that process, we make sure that we get those resolved. We get any charges that don't apply taken off. And then by the time your case ends, we are ready to start getting that final amount and get those reductions for it. Because it's our goal to put as much in your pocket as possible and not Medicare's, of course. It does sometimes take a little bit of time. Medicare is not fast. We do it as expediently as we can, but sometimes there are hindrances, but we will discuss those with you as we go if we foresee those happening. Once we have everything finalized, we will distribute if probate has been completed and was necessary to find out who all the heirs were and their distribution amount. And once we have that in place, then we would send those checks out. But all of that will be discussed with you upon settlement. But you're welcome to call with any questions that you have in the meantime about that, or any liens that you receive, or any case costs that you have questions about. We're always happy to answer any of that during the time of your case. And then once that's all done, we hopefully get your family some closure and you guys can move past this. My screen went blank, guys.
Okay, I can carry on from here. So pretty much, during your case, we wanted to find out about you and your loved one. We want to find out about your loved one in the best of times. I know that typically in the pre-lit process, we ask for photographs of the injuries. But in addition to photographs of the injuries, we want to see photographs of happier times, because we do use these later on if the case gets to mediation. So tell us your family story. Sometimes we often only look to the injuries, but we want to find out your family story. This is a partnership that we enter into with you. And so if you have any questions or ideas, please, we always welcome them. You can reach out to your case managers in pre-lit, your attorneys and paralegals for your case if it is in lit or when it gets to the lit department, and anyone in the admin team as well. Charlie and her team are very open and welcoming and very approachable if you have any questions. We ask you that you stay in touch, especially. There are some instances where we may need to get hold of you in a hurry. And so it's really important that you stay in touch. If you have a change of address, if you update your telephone number, if you change your email because your one email is full of a whole bunch of spam and you get a new one, please let us know what that new email address is. We also would ask you that you keep any important documents together. Copies of death certificates. I can't talk tonight. Copies of death certificates. Copies of any important documents. If your loved one is still alive and you have power of attorney over them, we ask you make sure, send us a copy for sure, but definitely also keep those important documents together and in a place that is accessible for you. We definitely cannot do this without you. We thank you for the trust that you have in our firm. Like we've said before, this is a partnership with you. We have the same goals of holding the facilities accountable. And so we ask you that you partner with us in order to do so. And in terms of staying connected, we have several platforms. We always want to make sure that we keep our communities informed. We have several places that you can go to for information, just about what's happening in our firm, as well as what's happening in the field of nursing home cases. We want to make sure that we educate the community as well. about things that you can look for if you've got a loved one in the nursing home. We are on YouTube, Instagram, Facebook, and LinkedIn. And we also have a QR code that you can scan for some additional information. And we also ask that you just follow us and just, get all the information that you can to make sure that you're as informed as possible as we go through your case. And our address and telephone and fax numbers, as well as our website, are shown up here. So we'll hang on to that page for a little bit if you need to take any of those details down. And I think that's the last slide that we have in our presentation. Is that right, Jacob?
Yep, that's it. So does anybody
Okay.
have any questions? We'll open it up to everybody. There's a chat at the bottom of your screen. So if you have any questions, put them in the chat window and we'll do our best to answer as many of them as possible. So it looks like we might have a few already.
I'll start with the first one. It looks like there's a question regarding guardianship and whether we need to close that out. If a loved one has passed, and we are so sorry for your loss, but if a loved one has passed and somebody did have guardianship over them during their life, that guardianship, of course, is no longer valid. So if there is a probate attorney involved, we would need to make sure and check to see whether that probate attorney has actually started the probate process. If they have not, we'd want to see if they are able to, so in this particular instance, we would at least speak to her. We'd like to speak to her, and I will reach out to you tomorrow just so that we can facilitate that.
Charlie, do you want to take those next three about liens, or I can? You're muted.
Not sure why everything was froze. Sorry, guys. When the question is, what do you mean by liens? That is where Medicare paid or Medicaid paid for the care of your loved one for the injury itself. If they had fallen and broken their hip and they went to the hospital, Medicare paid those bills. Well, they have the right to subrogate back those funds that they paid out for their injury because a third party is responsible. And that's how that lien works. And that's what I mean when you get a copy from Medicare or Medicaid. Sometimes you don't have any, sometimes you do. Sometimes it requires a heavy resolution to get it reduced or resolved. But we discussed that with you during this process of your case. And towards the end, you'll hear from us quite a bit discussing that. But you're more than welcome to ask any questions in that time period before your case settles about anything that you receive regarding a lien from Medicare or Medicaid. And it says, does their insurance get any charges during this process? That is the lien. It's the actual charges that they paid for at the hospital or facility or a specialty doctor that cared for your loved one for that injury. And then the next question is, what would be a case cost? A case cost is when we file a petition. We're actively showing that we filed a petition, we paid for it to be done with the court, and we paid for a citation to be served. Those are some of the fees. Medical record cost, if they charge us to copy, print, retrieve records, we pay for that up front to retrieve those records. If there's an expert required in your case and we have to pay for someone to look at those records and give his opinion in a written report, that is a fee that we pay for. And we pay for all of this up front, regardless of the outcome of your case. We go ahead and front these charges for you to get your case moving and working. So there are multiple charges that can apply, but it's a case by case situation. not all cases have the same charges. Not all cases have probate fees. Not all cases have medical record charges. It is a case by case nature. And if those apply, we do have that list itemized for you. You can ask for it any time. You can ask where your case costs are at any time, and we can go over those with you and provide you an itemized statement.
Yeah, and then just a follow-up question there. Does that come out at the end of the settlement? That's correct. So we don't collect those costs that we upfront until a settlement has been reached.
And we do try to keep those as minimal as possible. It is a necessary evil. We do our best to keep those down because our goal is to make sure that you're compensated as much as we possibly can. Of course, no money will ever compensate what you've been through, the loss that you've experienced, or the injuries that you've witnessed. But we do our best to get you the best outcome that we can.
Well, any other questions?
Those costs are separate from the attorney fees, and that's listed in the second paragraph of the contract that you have with us, which we can provide you and go over those with you at any time. And you're also welcome to call us separately if you'd like us to discuss further those costs and how that works and those fees. We're happy to take those calls at any time. You can just type in the message if you'd like a phone call, and we'd be happy to go over that with you.
Anybody else? All right, well, good. Well, I think that's it, unless anybody else has any other questions. But all of us, we're very appreciative for you guys taking some time to spend with us this afternoon, this evening, to just kind of walk you through the process. Again, this is a partnership with you, and we can't do this without you. So please stay in touch, and you are welcome to contact any one of us if you have questions, and look forward to working with you to try to get some resolution on your case. All right. Well, everybody have a good evening.
Good night.
Bye.